Chad Nicholson, Community Environmental Legal Defense Fund, also with the Pennsylvania Community Rights Network, which is a nonprofit organization which stands with communities who are standing up to assert their rights to prohibit harmful activities in their communities. Two quick disclaimers, since I do work for a law firm. The first is that I'm not a lawyer, so I'm not giving legal advice today. I'm basically going to describe the system of governance that we have in Pennsylvania and municipalities. But I'm not giving legal advice. I'm not telling you that you should or should not do something. The second disclaimer, and this is a mouthful, is that as a nonprofit law firm, we are a 501c3 organization, which means that we are not a lobbying or an advocacy organization. I'm not here today to tell you that you should or should not do something. I'm not, as was mentioned in the paper, an activist that's coming in here to tell you to ban things. That was put in there without talking with me first. I just put that in for no apparent reason. Anyways, I'm going to share our experiences in organization, what we've learned over the years, and discuss how communities under our current legal system feel like they're handcuffed when it comes to dealing with harmful activities because they're being told by the state that they can't stop it. They're being told by the state that they have to allow it. So we're going to discuss what that structure looks like and how communities are pushing back against that to actually stand up and protect themselves in the face of a state government or corporations that are telling them they can't protect themselves. So that's where we're going to go. To get there, I need to go back in time a little bit to describe the arc of our organizational history, because the work that we do today, which is what we call rights-based work, is very different from where we started out in 1995 when our organization opened. So in 95, our organization opened by a guy named Thomas Lindsay. He's our executive director and lead counsel. And he came out of law school and went to law school in Harrisburg to be an environmental attorney. As he tells the story, he came out of law school, and environmental attorneys in this country, in the United States, are told that we have the best environmental laws in the world in the United States. Our environmental laws are so good that we actually export our environmental laws to other countries. We say, here, these are great laws. You should model your own environmental legislation on what we've done in the United States because our laws are so good. That's what the environmental attorneys are taught. So as he came out of law school in Pennsylvania and looked across the countryside, he saw a lot of mostly rural communities that were having harmful projects forced on them that they didn't want. A lot of stuff back then were things like factory farms, so 80, 100,000 head hog factory farms that were being forced on communities. The spreading of sewage sludge, toxic sewage sludge within communities that didn't want it, toxic waste incinerators, things like that. Big, harmful industrial projects that were being forced into communities that didn't want them. So he said to himself, well, if our environmental laws are so good, and yet these communities are receiving these projects that they don't want, why is that? His answer to that question at that time was it must be one of two things. Either there's not enough lawyers, we define the problem very differently today, but either there's not enough lawyers, or if there are enough lawyers, the communities that most need those lawyers don't have the resources to hire those lawyers to enforce the environmental laws to protect those communities. So today, most of the communities I work with are pretty rural, don't have a lot of cash, and so he said we either don't have enough lawyers, or if we do, the communities that most need them don't have the money they need to hire these law firms out of Philly or Pittsburgh or wherever to come in and protect the communities. So he opened the Legal Defense Fund to try to plug those two gaps in the system, that we would provide free legal services to communities facing harmful activities that were trying to be forced into those communities against the community's will. That was what we opened to do. As you can imagine, when you hang up your shingle and you offer free legal services, your phone starts ringing a lot, very quickly. Within a couple of years, we were representing over 400 municipal governments and community groups across Pennsylvania. There's about 2,500 total municipalities in Pennsylvania, so to put that in perspective, within a couple of years, we were representing close to a fifth of the total municipalities in Pennsylvania, dealing with a lot of these issues, factory farms, sewage sludge, stuff like that. These days, a lot of it's related to gas and oil infrastructure, so fracking, toxic waste injection, pipelines, things like that. But I still have meetings going on with factory farms. I had a sludge meeting last night, so a lot of stuff going on. So the phone call back then, and even today, is almost always the same that comes into our organization, which is you have somebody on the other end of the line that's usually very energetic and very worried, and they say, you wouldn't believe what's about to happen. This corporation is wanting to come into our community to put this factory farm in or this toxic waste injection well in the middle of our community, and we don't want it for all these reasons. All the harms, and people get very educated on all the harms. If it's fracking, they're concerned about water contamination, they're concerned about trucks coming through, they're concerned about water contamination underground, surface water, the waste, all these types of things, air quality, all that stuff. For factory farms, sewage sludge, a lot of it's the same. Water quality contamination, trucks on the roads, all kinds of things. Folks have their concerns down pat. They would let us know what those concerns were. We already knew them, but they had to tell us what their own concerns were. And we would say, all right, you don't want this thing coming in, we can help you. And what that help looked like back then, as we were a traditional, conventional environmental law firm, we would work with the community to appeal the permit that had been issued to the corporation to allow that activity to come into the community. None of these things can happen unless those corporations have a permit in hand. Fracking can't happen, injection wells can't happen, factory farms can't be put in, sewage sludge can't be spread, water can't be withdrawn unless the corporations intending to do those activities have a permit from a state or a federal regulatory agency. So in Pennsylvania, for the most part, the Department of Environmental Protection is the state regulatory agency that governs fracking. Injection wells are a federal matter. They're governed by the Environmental Protection Agency for the most part. If it's a pipeline that crosses state lines, that's usually a federal matter, the Federal Energy Regulatory Commission. Either way, all of these regulatory agencies have to issue permits to these corporations that allow that corporation to engage in activity. There can't be any fracking, toxic waste injection, sludge spreading, any of that stuff unless that corporation has a permit in hand from the DEP or the relevant agency that allows them to do it. You have to have a permit. So logically, from our perspective, and this is still what most environmental groups do today, is you said, well, the logical route to fight this thing then is to try to appeal the permit to show that the permit that has been issued is a bad idea. You have to show that this permit is a bad idea to give it to this corporation to allow this project to come in. So we would look through the permit for flaws and deficiencies, things that were wrong with it. They put up the wrong bond amount. Their road study didn't take into account new trucks that were on the road. Their wetland study was 10 years out of date. Things like that. Their noise study was, didn't take into account the trucks, whatever it was. We would look for things that were wrong, deficient within the permit application. We would find them all, we would compile them into a list. We would take it before a judge or the environmental hearing board of the DEP, whoever the relevant person was, judicial arm, and we would say, look, Your Honor, this permit clearly has been issued in error because all of these things are required to be there inside the permit, and there's all these flaws and deficiencies. There's all these things wrong with it that the corporation didn't do correctly. And so we got to toss the permit. By and large, we would win that first round of permit appeals. We had a win-loss record on paper of something like 180 wins to 4 losses in court. The judge would say, you know what, you're absolutely right. The permit application criteria requires all of these things to be here and to be in order. You identified all these things that were wrong. Therefore, the permit is not going to be issued. That project cannot proceed within that community. Tosses the permit. We would go back to the community group's houses and we would drink beer and eat snacks and sit around kitchen tables and celebrate. And everybody would say, the system works, right? Community group got educated. They identified a problem that they didn't want that was going to harm their community. They educated themselves and the broader community. They got a competent environmental law firm involved. We were good at our job. We came in, we did the permit appeal. The judge actually agreed with the community and with us. The permit gets tossed, no factory farm, no sewage sludge, no fracking, none of that stuff. Great news, the system works. Except, of course, what would happen 30 days, 60 days, 90 days later, I see some heads nodding, the corporation would resubmit that permit application, and this time they would have fixed and filled in all the flaws and deficiencies that we had identified for them. They would actually thank us, tongue-in-cheek, in court. We were actually helping them to build better bulletproof permits. And the sad part about that is we weren't even costing them money at that point. They could write off those fights as a cost of doing business on their taxes. They could write those costs off. We weren't costing them money. So 60 days later, the corporation would resubmit the permit application. The community group would back on the phone with us and say, hey, look, it's 2 months later. We still don't want the factory farm in the middle of our community. So you guys are the experts, the lawyers, meaning us. We need you to come back in, do that thing you did the first time. We know what you're doing. Get that permit tossed because we still don't want the sludge spread in our community. We still don't want the frack pad. We don't want the toxic waste, whatever it is. To which we found ourselves having to explain to them that we had no other legal levers left to pull. There were no other avenues that we could pursue to try to get that permit tossed because the legal language is administratively complete. If the permit application is administratively complete, meaning all the I's are dotted, the T's are crossed, all of the things that are required to be there by the regulatory agency, if they're all there, the permit has to issue. It shall issue as a matter of right to that corporation. Their regulatory agency doesn't have discretion at that point to decide whether or not they think it's a good idea for that community. They don't have to take into account the community's perspective on the issue. If the application is administratively complete, it has to issue, and it legalizes that activity to take place within the communities. So we had to explain that to them and say, we're sorry, we fought our best the first time around, we delayed it, we held it off for a while, we hoped maybe they would go somewhere else. But at this point, we don't have any other levers left to pull. We apologize. If we could help you more, we would, but we can't. And again, this is still the work most groups are doing today. So the irony in this whole situation was we got invited to the White House as one of the best environmental law firms in the country at that time because of our win-loss record. Got down there, got some awards and accolades and a whole bunch of other crap. The ironic part was if you looked at the communities that we were representing, it told a very different story, which is that they ended up getting the harms that they didn't want. They didn't find that they had any remedies within the system for them. So we almost closed up shop. We said we got better things to do than help corporations build better permit applications. That's not why we opened up. And so we almost closed up. We're going to move on and do some other stuff. Till some small rural communities, mostly conservative, South Central Pennsylvania farming communities began asking us a very simple question, which we started asking ourselves as well. And the question was why? Why don't we have any other legal levers in this situation? Why can't we actually just come together as a community and say we don't want this thing because clearly it's going to harm us? Why can't we just pass a one-paragraph ordinance that prohibits the spreading of toxic sludge, that prohibits the injection well? We thought we had a democracy. And a lot of these meetings were in, salt sheds in small rural township buildings. They would pull out copies of the Pennsylvania Constitution, point to it, and say, look, it says right here, Article 1, Section 2, all power is inherent in the people. So why is it that the people don't seem to have any governing authority in this situation? Why do we have to put our lives on hold and become experts on wetlands and on traffic patterns and hire our own experts and hire scientists and hire lawyers and all these other things? Why do we have to look to the experts when we're the ones that are the experts? We're the ones that live here. We know what's good for our community. Why can't we just exercise democracy, consent to the governed, all these things that we've been told that we have, and just say we don't want it? Why can't we do that? Because we don't know. We're environmental lawyers, not constitutional lawyers. We're sorry. But we will begin to look for some answers for you. And that began our evolution as an organization. It took 3 or 4 years. We started looking deep into the history and the law books. We went all the way back to the 1200s in the Magna Carta. We do these things called democracy schools today in communities that we're active with. They're 1.5-day workshops that actually trace the legal and political history of our country to look where it came from, to help us understand how we got in a position where we don't seem to have any authority in our communities anymore to make decisions that stick on important issues. How did we get there? We dug into the history. We explained it to ourselves, and then we explained it to the communities, and unfortunately, this is the answer we came up with, which is that there are currently legal constraints in place that control our communities inside a tightly constructed box right here. These are our communities. Pennsylvania municipalities, we've got townships, boroughs, and cities. No cities and powder counties, just townships and boroughs. So, this is where our communities are, safely inside a box of legal doctrines that we didn't create, that corporate lawyers and legislators in Harrisburg and in D.C. created, and that govern what we can and cannot do in our communities on important issues. I'm going to run through this box very quickly. It doesn't matter the issue. These legal doctrines are all the same. We've got litigation going on a variety of fronts right now, from injection wells to fracking to water withdrawals, and all of these doctrines are basically the same. It doesn't matter the issue. I'm going to run through this very quickly. I could spend 5 hours on it today, and everybody would get very angry, and they don't want to do it. So I'm going to run through it very, very quickly. The first doctrine is state or federal preemption. Folks may have heard the word preemption before regarding what communities can or can't do regarding fracking, injection wells, sewage sludge. Preemption is where the state or federal level of government passes preemptive law that removes authority from our communities to legislate on specific issues. So when it comes to fracking, we've been told that we've been preempted by the state to prohibit fracking in our municipalities. We've been told we can zone it. I'll get back to zoning in a minute. But we can't stop it because the state has passed preemptive legislation that tells us we can't stop it in our communities. The state will decide whether or not we can stop it, and they'll tell us. Same thing goes for sewage sludge spreading. The state has preempted communities from banning the spreading of toxic sewage sludge in their communities. The state has passed preemptive legislation prohibiting municipalities from banning factory farms in their communities. We did a preemptive history in Pennsylvania a couple of years ago, and it was about an 80-page document which traced all the times that Harrisburg has passed preemptive legislation over the last 100 years, and it's on almost every issue you can think of, from agriculture to timber mining to forestry to coal mining to GMOs and food, anything you can think of, water withdrawals, fracking, injection wells, toxic waste, all that stuff. The state has passed preemptive legislation which removes authority from our communities to govern on those issues. Somebody else in Harrisburg is passing laws to tell you in your communities, you don't get to govern on those things. It's beyond your pay grade. Harrisburg will decide those things for you and tell you what you can and cannot do. They will actually preempt you from making law on those issues. Preemptive legislation. Usually at this point, folks say, well, how can they do that? You know, we've got the Constitution that says all powers inherent in the people. We've got all these other local tools. We've got zoning and stuff like that. So how can the state actually remove authority from the communities and tell us we don't get to have a say in those things? It's governed by a legal relationship called Dillon's Rule, which defines the state as the parent and the municipality as a child. That's the legal relationship right now between the state and our municipalities. Doesn't matter if you're a borough or a township, the state is the parent and the municipality is the child, according to the law books. Which means that the state can give you authority to do something or not do something, and it can remove that authority any time that it wants. It can remove that authority and preempt you from having a say. So there used to be more authority in communities to have say over things like factory farms and sewage sludge, until the trade lobbies for those industries decided they didn't want to deal with municipalities every single time. They went straight to our state legislature and had the legislature remove that authority from our communities via Dillon's Rule. State parent, municipal child. The state can slap our hand anytime that they want and tell us that it's beyond our pay grade to legislate. Keep in mind the issues I just mentioned. Food policy, water policy, energy policy. The actual things we need to live just to wake up in the morning, the fundamentals of our lives, we don't have the authority to govern on those things. Somebody in Harrisburg or DC makes those decisions and then tells us what we can or cannot do. Third side of the box is what we call corporate rights. I put rights in quotation marks. Corporations are just pieces of paper. They're chartered entities. By themselves, they're not good or bad. I work for a corporation. Corporations are basically charters that give a group of people permission to engage in certain sets of activities. And they allow that corporation, that group of people, to have wealth. Basically, corporations are wealth on paper. The charters that actually give life to those corporations are issued in the name of the state that corporation is chartered within. So, our corporation, the Legal Defense Fund, is chartered in Pennsylvania. That means that the state of Pennsylvania and the people living here have actually got their name on the corporate charter. The corporations don't exist unless they're given permission by the state and the people within that state. They're actually creatures. They're created by the state itself. However, corporations have now been found by the U.S. Supreme Court to have constitutional Bill of Rights protections as persons under the law. So corporations, like JKLM, or the Legal Defense Fund, or Seneca Resources, or any other agribusiness corporation, have First Amendment protections to free speech. They have Fourth Amendment protections to be free from unreasonable searches and seizures. They have Fifth Amendment protections under due process and to be free from governmental takings of corporate property. They have Sixth Amendment rights to face their accusers in a court of law. They have 14th Amendment rights to equal protection under the law. They've got Commerce Clause protections, Contract Clause protections. All things in our federal and state constitutions that were intended and put in there to apply to people like those of us in this room today have now been conferred on corporations by the U.S. Supreme Court. They may sound like a bunch of gobbledygook and a bunch of legal mumbo-jumbo, and it is, but what it means in short is that 7 people on a corporate board of directors headquartered in a state far from here can use those corporate rights to override what a majority of people living within your community may want to see. How does that work? If you tell a drilling company you don't want them to do business in your community, they can sue you under the 14th Amendment, just to take one example. Folks may remember the 14th Amendment was passed in 1868 after the Civil War. It's the Equal Protection Clause of the Constitution, and it was put in there to make sure that the law applied equally to all classes of people, to make sure the law applied equally to whites as well as to blacks after the Civil War. Equal protection of the law for all people. Because corporations are now seen as persons, they can use that against you and say, if you don't allow this drilling corporation in your community, you're not applying law equally to them, and they can sue you for discrimination, for violating the corporate equal protection rights under the federal Constitution. We've seen it happen with our work. We've seen it happen in a bunch of other places as well. It sounds crazy, and it is, but again, remember, 7 people on a corporate board can use those corporate rights to override what the majority of people living in your community may want to see, even if that corporation is wanting to put in something that's going to harm. The last side of the box is what we call around the office the regulatory fallacy. It's basically the idea that our regulatory agencies are going to be there to protect us, that if we have a concern about a specific activity like fracking or injection wells or sewage sludge, that we go to our regulatory agencies and ask them for help, ask them to protect us. They've got great sounding names: Department of Environmental Protection, Environmental Protection Agency, Fish and Game Commission, all these types of things, great sounding names. But we have to remember what they were actually chartered to do and what their job is right now, which is not to actually protect the environment. Their job is to issue permits to corporations. And those permits legalize a certain amount of harm that goes along with those activities. So, a corporation grabs a permit from the DEP, they can now pollute a certain amount. The local water supply, the air, the roads, whatever it may be, that permit actually legalizes harm to go along with those activities. It permits something to happen that would otherwise be illegal if that permit was not given to that corporation. We have to understand that when we engage with the regulatory agency, we're on the defense from the start. It's a regulatory agency. It assumes that something is going to happen, and the regulatory agency's job is to regulate the amount of harm associated with that activity by issuing permits to legalize a certain amount of harm that goes along with that activity. We learned all this the hard way. So we're already on defense. It's got nothing to do with democratic control. It's got nothing to do with stopping the harm associated with the activity. It's everything to do with regulating the harm and trying to get a better deal through the permits. We end up fighting over the permit. Can we get the well pad moved? Can we get the water contamination remediated after it's already happened? Can we get water buffaloes brought in and put in communities' front yards? Can we get impact fees to pay for our roads that are being messed up by the trucks on there? It's everything to do with trying to defensively and after the fact get something back for our community. It's got nothing to do with giving our communities control to stop the harm up front. It regulates. That's what our regulatory agencies do. The regulatory agencies also issue, well, they don't issue, they create hearings on these matters. How many folks in here have been to a hearing before? Couple. Yeah, sorry about that. I know they're not fun. There's a reason that they're called hearings and not doings. The regulatory agencies and the corporate boys of those things can hear what you have to say, but it doesn't actually have to have an effect on whether or not they issue the permits. We use these meetings these days to stage how the system actually works and have community members press the regulators on the point. Is anything that we actually say here tonight going to have an effect on whether or not this permit is issued? If you press them long enough, the answer is always no. The answer will always be, if everything that's in the permit application criteria is met, we will issue it. But we are glad that you're here. We're happy to hear your comments. We will try to take them into account. We will do our best to help the community. You may also write to us with public comments. There's a reason they're called comments. You can write 5 million of them. And they may read them, they may even issue a response to them, and then they're going to shove them in a big fat drawer with all the other comments that everybody else has written over the years, and it doesn't have an effect on whether or not the permit issues either. So we have to understand who the regulatory agencies work for. We didn't create them in our communities. They were actually created by the corporations. I know it sounds crazy, and if folks want to hear the dirty history of it, I'm happy to get into it, but it's going to be a long story. But the regulations are actually written by the corporations, and then they're governed by these regulatory agencies, and those regulatory agencies actually legalize harm by the issuance of permits. So that's what we've got. So, we explained this box to ourselves. We explained it to the communities we were working with at the time, and this is their words, not mine, but I agree with it. They said, well, if that's true, you guys are the experts, if what that says is actually true, that's bullshit, number one. And number two, we would be fools to continue banging our heads up against the inside of this box that we didn't create, trying to get remedies and protections for our communities by using laws and legal doctrines that weren't put in place in the first place to actually protect our communities. We didn't create this thing. Somebody else did, and it wasn't put in place to protect our communities. It was put in place to legalize a certain amount of harm, to actually take away our democratic authority. So, at this point, I see some long faces around the room because it's a pretty grim picture, but this is the reality. The community group said to us, look, if we're going to have a fight, let's not fight about where the sludge is going to be spread, or what hours the trucks are going to come through, or what hours the loading dock lights are going to be on, or those types of things. Let's actually have a fight about rights. Let's have a fight about who makes the decisions in our community. Let's have a fight about democratic authority. If we're going to have a fight, there's going to be a legal battle or whatever other kind of battle, let's make it on our terms, not the terms that somebody else set up for us. And so these communities ask us to start passing or to writing ordinances with them based on the community, based on the rights of the community to self-government. Pretty basic concept. Most of us think we have it until we try to exercise it. The idea that those who are most affected by the decisions should be the ones that get to make those decisions. Self-government, community self-government. People affected get to be the decision makers, not Harrisburg and not the corporations. So we began drafting those ordinances. There's now been over 100 passed in Pennsylvania by municipalities of various sizes on various issues that prohibit harmful corporate activities as violations of the rights of the people living in those communities. So it's a rights-based argument. It's local rights-based work that actually calls into question this system of law and says we don't recognize this as legitimate if Harrisburg or the corporation is telling us we don't have the authority to protect our community. We're going to stand up, assert our rights, act like we have them, and protect our community anyways. And here's a law that says that we have the authority to do it. And if we're going to have a legal battle or a battle in the newspapers or wherever it's going to be, let's have it be on the terms that the community wants, not the terms that the corporation wants. So as mentioned, there's over 100 communities in Pennsylvania that have passed some version of these laws. Almost 200 communities now across the country and 10 states that have passed some version of these laws, prohibiting harmful activities as violations of the rights of the people living within those communities. It sounds good, but that can invite with it some consequences. And I'm going to get into those because it can invite lawsuits, and those are scary, usually especially to more rural communities, which often are financially strapped and don't have a lot of cash to get into a drawn-out legal battle with a corporation, so I'll get into that a little bit. But I'll just say, I understand, and usually by the time I'm at meetings like this, folks are upset, or at least want more from their supervisors, from their elected officials, because they want them to stand up and do something. I'm actually sympathetic to the supervisors in a lot of these situations. The number one thing that I hear from municipal officials across Pennsylvania is that they feel like their hands are tied, that they're handcuffed, that they don't actually have the tools they need to make decisions. Because they take an oath of office. All the elected officials do, and it requires them to do two things. The first is to uphold state and federal law, and the second thing is to uphold with fidelity the duties of their office. Uphold state and federal law, and uphold with fidelity the duties of office, which include protecting the health and safety of the community that elected them. So these elected officials look at me or they look at the community and say, how can I uphold state law, which currently legalizes something harmful to come in here, while also upholding the duties of my office, which is protecting the community? How can I do both? How can I allow this in while also protecting my community, knowing that this activity is going to harm them? Usually at this point, they don't turn to the community members for their advice. They turn to the municipal solicitor, the lawyer for the township or the borough. And we have to remember that the solicitor in these cases doesn't actually work for the people of that municipality. He works to protect the assets of the municipal corporation. All townships, all boroughs, all cities are public municipal corporations. The solicitors are hired by the elected officials to protect the assets of that corporation. So the solicitor is going to look at a challenge to the legal structure like this and say, this might get us in hot water with the corporation or with the state. You'd best not challenge that and pass a law. You just got to allow this in because it's legal. Don't get yourself into a confrontation here, because his interest, the solicitor's interest, is in protecting the assets of the municipal corporation, not protecting the people that live there. Just doing his job. That's how solicitors across the state measure their worth. It's by how long they've been able to keep their client from getting sued. That's their interest. How can they keep their client from getting sued? And they say, if you challenge the law as it is, if you challenge this thing and say that the corporation can't come in, even if the state tells them to, you might get yourself embroiled in a lawsuit, and that could, cost us some money. So they advise against it. The solicitors, if the people want to continue on at this point, need to be reminded that they don't get to make law. It was the elected officials that were put in that position to be the ones that legislate and make law. It's not the solicitor, it's the people that were elected to office. And the communities need to stand up and stand with their elected officials and let them know that they understand the opinion of this solicitor, but that they still want to move forward and challenge this thing, that the community is behind them, that they're willing to go forward with the fight because it's that important. All of these things will cost something. It doesn't matter what the issue is. Fracking, sewage sludge, factory farms, all of these things are going to cost something in the community. There's a cost if you do nothing, which is that the community is almost assuredly going to be harmed at some point. There's a cost if you engage with the regulatory system. At that point, you assume that the activity is going to come in, and your best option is to try to regulate it. You cost your actual sovereignty, your democratic authority, and at some point, harms are still going to happen. What is regulation? What does zoning allow our communities to do? Zoning allows us to decide which neighbors we like the least when it comes to the activities. If the activity is harmful, why should one person be sacrificed to it within the communities? If the activity is harmful, why do we have to say that our communities have to accept it and put it somewhere? Zoning is a tool of surrender. It assumes it's going to happen. We have to decide which neighbors are going to be sacrificed, whose kids drive too fast, or whose dogs bark the loudest. That's who's going to get it. That's what zoning and regulation allows us to do. That comes with costs. There's also costs of standing up and fighting back if you go the rights-based route or a different route, which is that you could pick a fight with the corporation. At that point, you have to decide if you want to pick a fight based on your rights or not. And if you're willing to stand up and say, the costs to our health and safety are so great that we're willing to deal with this as a community and risk a lawsuit from the corporation because it's the right thing to do. Not necessarily because it might cost our municipalities some money, but because our health and our safety, our democratic rights, our ability to be the ones that determine our future are more important than the threat of a lawsuit from an out-of-area corporation whose only interest in our community is in putting in an activity that comes with inherent harms that they're going to profit from. That's how it breaks down. All these things come with costs. The communities themselves have to decide which costs and benefits outweigh the others. So that's kind of where it's at. If folks decide to work with us, and again, I don't barge into communities, I only work with communities that ask our organization to work with them. We work with them to draft the ordinances. We work with municipal elected officials as well as community groups to write the ordinances in alignment with the values of the community and the rights of the community. If the community does get that ordinance put in place and they get challenged by a corporation, we do offer pro bono legal services to aid in the defense of that ordinance. That doesn't mean that we pick up the costs if the corporation, sues the community for damages, which they might try to do. Quick example, representing a community right now in Indiana County, Grant Township, who passed a rights-based ordinance prohibiting the injection of fracking waste within the township. They're all in private wells. The corporation that wants to inject there, PGE, is one of the top 10 polluters in Pennsylvania. They have a history of violations within the state, and they want to dump toxic waste in the middle of this community. The community and the permits were issued to the corporation. The community said, well, the regulatory agencies have failed us. We are going to pass a law, our own law, that says you can't do this because it would violate our rights. We drafted that with them. They passed it. They were then sued by PGE. It's in federal court right now, and it's winding its way through it. It might be a little while yet. We don't know what the outcome's going to be, but basically the community there decided that their rights were going to be violated, and they were willing to stand up and take on this corporation in court. Even if it meant cost to their community. Again, we're providing pro bono legal representation, but basically the corporation has threatened that community with bankruptcy. They're threatening to sue them into bankruptcy, that municipal corporation. And the folks there said, still doesn't matter. We're willing to stand up and assert our rights. You can have our dump truck if that's what you want. It's a small rural community with an operating budget of about $100,000 per year. And they said, our health and safety, our water, our actual dignity of not being bossed around by an out-of-area corporation with their violations is more important, and we're willing to take that on. And if you're going to bankrupt us, it's going to look pretty bad in PR and in a lot of other ways as well. So this stuff can get real. There's consequences no matter which avenue you pursue. I can sit here and tell you that there's a panacea and that there's an easy way out, because if there was, I wouldn't be standing in front of you and we all would have followed that easy way out at this point. There's hard choices all around. For the communities that have passed these ordinances across the nation at this point, banning the activities they didn't want, not one of those communities has received the activity that they prohibited to this point. Give me one quick second to wrap up, and then we'll get to Q&A. Again, it doesn't mean that it won't happen at some point in the future, but to date, over the last 10 years that communities have been passing these, the communities that have passed them have not received the activity that they didn't want. It's hard stuff. It can divide the communities. We're taught to resist in different ways. We're taught that the regulatory agencies are there for us. We're taught to talk to our legislators in Harrisburg. The communities that we work with, those communities have stopped believing that there's going to be somebody else, somewhere else to save them, and have started doing the work in the places where they live because they think they're the ones that are the experts and they should have the decision-making authority. So it's a difference, a lot of differences in terms of what we decide to do if we identify and think there's a problem. I've seen some hands start to go up, so I think at that point I'm going to stop and just open it up to Q&A at this point and leave you with this. You've got 3 options if you think there's something bad in your community. You can do nothing and get it and continue to put up with it. You can try to work through the regulatory route and try to get a better deal, get harmed a little bit less, decide which part of your community is the least populated or which neighbors you like the least, or you can stand up and assert your rights, say that it shouldn't be forced on anybody in their community and we're willing to fight for it. This is civil rights work. In some ways this work draws on the abolitionists and suffragists, people who found themselves in situations like a lot of communities find themselves in right now, where the people living in those communities didn't have legal remedies available to them. Women weren't allowed to vote. They asked nicely, they were told no, not yet. They actually had to challenge the law. The women's suffrage movement passed over 400 local and state laws in their 50-year movement that challenged the federal law that said that they couldn't vote. They went and voted anyways, even when they were told that they couldn't. They did it because they knew they had the right to, they knew that they were right, and they knew they had the authority to do it, and they just kept doing it. And that's eventually what forced the change at the state and federal level. So that's where this work kind of falls in the heels of it. It takes its inspiration from folks who found themselves without remedies, said we're not going to get answers from the corporations or from Harrisburg or DC at this point. We're going to have to do it ourselves and push back against illegitimate and unjust law and put a different structure into place, which is about recognizing the rights of our community and protecting them. So I'm going to stop there. So I hand here and then over here. Was there any? Yeah, let's do quick.
Well, I agree with much of what you said. I think what bothers me, and maybe it's under corporate rights, I think the greatest challenge in our area is that a lot of people have signed leases with these corporations. They signed them early before they knew the real impacts that unconventional drilling was going to bring. And, for various reasons they signed. So I think many people who have signed leases are hoping for the best. And I'm wondering, I think we're a minority here, a distinct minority that showed up for this meeting, maybe because of the bad publicity by an article I had seen because I've been away this week. But how do you, I've seen like at a hearing in Wellsboro this past year where a company called Clean Earth was going to bring in drill cuttings to the airport outside of Wellsboro and use those drill cuttings to extend a runway. And groups like Pine Creek Headwaters Protection Group did a lot of research, called for the hearing with DEP, we had the hearing. It's as you said, we didn't convince DEP that they shouldn't issue the permit. But I think the group, that hearing, and people who spoke at that hearing did convince the community and did convince their commissioners, who, and the borough officials who consequently withdrew their support for the project and made it less comfortable for Clean Earth, to go ahead. Not that that might have, would ultimately have stopped them. Maybe there were other things that the regulatory agency, they had returned the permit application saying it was incomplete, and Clean Earth withdrew. I see our challenge is with maybe the legal complications involved with convincing a community that has signed leases with this industry, that, hey, this isn't a good idea. You can't back out the lease, can you?
Yeah, so a couple things. First, just to your story about the regulatory hearing. They can resubmit that application anytime they want. Mm-hmm. And so there's all this urban legend and lore about wins within the regulatory system. Mm-hmm. There's never been people that actually stop things from the regulatory system. Usually, if a community is dedicated enough, they hold bake sales and other fundraisers, and they hire attorneys and scientists, and maybe they find some Native American artifacts and things like that. They throw up a whole bunch of roadblocks in the regulatory system. Things that the corporation has to keep overcoming and dealing with. At some point, maybe the corporation decides it's easier to go to a different community and do that, rather than continue to put up with whatever roadblocks that dedicated community is putting up. But it didn't actually stop them. They voluntarily withdrew, and now they went to another community, and that community is now going to deal with it and fight them off. And it also doesn't stop them from coming back and resubmitting the original permit application again at a different time. And so it's not a win. And it also doesn't mean that it makes it any easier for anybody anywhere else to fight these things off. So we fight these things as community members, one issue at a time, put your lives on hold for 3 to 5 years. Maybe right then it was the drill cuttings, maybe a couple of years before that it was a Walmart or something, maybe 3 years before that it that was sewage sludge, 5 years before that it was a factory farm. All these issues require a massive amount of community engagement and involvement. And they require all of our resources, put our lives on hold, we haven't seen our families, we dip into our savings to pay, we show up at hearings, we go down to Harrisburg, we protest all this stuff. It never actually stops it, and it doesn't ever make it any easier for any other community to stop these things either. Like, it never changes the system so that other people benefit from all of the hard work that gets put into those hearings and all of that stuff. All that stuff is community by community by community by community, issue by issue by issue by issue. And so from our perspective, that also is a very narrow way of going about this, because at some point we've got to deal with the structure so that the assumption is safety. The assumption is that the people in the community have the authority, and the assumption is that if the corporation wants to come in with a harmful activity, they get to go through the hearing process, and they get to put their own corporate lives on hold for 5 years, and they have to come begging to the community to come in, not the other way around. Right now, we basically become prisoners in our own communities in situations like that. We have to go to those hearings, and the corporation is assumed that they can come in, and we have to come up with all these reasons why they shouldn't be able to. It's a complete inversion of the democratic process. So to say that all those things don't make it easier, even when you get a so-called win or the corporation withdraws, it never makes it easier to win those battles at any point in the future for your community or anybody else. And that's why our work is dealing with the structure itself, trying to change it. So the assumption is that communities get to be the deciders. Second point, the lease stuff is difficult, and there's not an easy conversation here. In this work that we do, I said socialism and some things online or something. Our work is not anti-property rights, private property rights stuff. It's actually about protecting property rights in many ways. Because right now, people are claiming, well, it's my property, I can do what I want, I can lease it up, and you can't stop me, it's my private property rights. However, private property rights don't bring with them the authority to harm somebody else's ability to enjoy their own private property. And this stuff doesn't just stay on one person's property. You see how many wells were contaminated, just the most recent one. I mean, there's contamination and consequences that extend far beyond the property of whoever is having the drill head put in, or whoever is going to receive the benefits of the lease. The truck traffic, the water contamination, the air quality contamination, all that stuff. So the point being that the private property rights from our perspective only goes so far, because you can't use your property in a way that would violate somebody else's private property rights as well, or somebody else's ability to enjoy your own property. So those are the real hard conversations. They're not ones that I can tell you how to, you have to have those in your own community in the way that you do. But just to say, when people say it's a private property rights issue, it's actually not. It's about the community's ability to protect itself. And we actually ban and prohibit harmful stuff all the time. Nuisances like landfills, or we can't burn old tires in a lot of communities, or there's restrictions on burn days and stuff like that. Things that are going to harm people, and where an activity is going to harm somebody beyond the property that it's taking place on, we put restrictions and prohibitions on those things all the time. And so we think it's weird that we think it's crazy to do that for something that's as harmful, or potentially harmful, as fracking. And there's many consequences that have come with it. It's crazy to me that we accepted that we can't burn old tires in our communities, but we don't accept it that we can't stop something that has proven so many times to be as harmful as fracking. So it's a change in the way we talk about this in the first place. To your point, the legal stuff from our perspective doesn't make a difference. If a community puts one of these in place, it doesn't matter who's leased up, because it becomes a community rights issue at this point. It's about protecting the community as a whole. And with that comes protecting the individual property owners. How can you have a community if people's water is contaminated? How can you have a community if all the property values go down and you can't sell your house because nobody wants to move into a place because all the trucks are going by, or it's next to a containment pond that's filled with toxic fracking residue, all that stuff. There's a lot of issues here that don't come to light, and this type of work actually brings those out, and it draws into very, very clear perspective and the distinctions between what property rights actually are, where they end, and where the community's ability to protect the broader community, water, things like that, comes in. So we don't have those conversations right now. The regulatory system doesn't allow us to.